Hi everyone, so today is the first mini lecture for the rest of this constitutional law class, and what we're talking about today is the Commerce Clause of the US Constitution. So as you all know, we've been talking about the Commerce Clause for about a month now, and we talked about the reason for the Commerce Clause, about how the Articles of Confederation didn't give the federal government power to tax people directly, and that states had to tax people and then give that money to the federal government. And it was difficult for the federal government to do this, and difficult to have states comply. And that also the federal government lacked the power to regulate commerce. The 13 different colonies were being inefficient and ineffective. They weren't working together, but they were treating each other like hostile countries. So if you think to some of the early Commerce Clause cases that we've talked about, things like one state, New York, giving a complete right to boats, versus New Jersey giving complete rights to other places. So you had states not working together and nothing that the federal government could really do about that. So what we have is, and we've talked about this a bunch before too, but about how Alexander Hamilton had a plan when helping draft the Constitution, and having an early role and say in how courts interpreted the Constitution, that a big goal was having the country be able to go from agricultural, mostly farms, to industrial, to have banking, to have commerce. So the Commerce Clause was incredibly important, and the part that we've been focusing on is the part that says states can the part that we've been focusing on is the part that says the federal government can regulate commerce between the states, which is called the Interstate Commerce Clause. So the types of questions we've been asking is, what is commerce? What is between states? So we know when the federal government can regulate commerce. Now remember, the federal government, the list of what the federal government can do in Article 1, Section 8 is limited. So if it's not on that list, then the federal government can't do it. So if something isn't commerce, then Congress can't make a law about it unless they have another reason to make a law. So what we have is that the Commerce Clause didn't really get used until the 19th century, which is the 1800s, and really not much until the Civil War, because that's when this country started getting more industrial, right? And so the Commerce Clause, and this would make sense, didn't start being used by Congress until we moved from being primarily farm-based to a country with more industry. And this is all stuff we talked about before, so just to finish the review, at first, the Supreme Court, the first big case we have, Gibbons versus Ogden, it had this big view of commerce. Commerce is anything, that's in this stream. And then after then, from, the 1800s until the 1930s, the Supreme Court started knocking down all these things that Congress wanted to do, okay? So we talked about the cases where the Supreme Court said that Congress can't make child labor laws, that Congress doesn't have the power to do all sorts of things, okay? And then we learned about how with Franklin Delano Roosevelt and the Great Depression and the New Deal, we needed, Congress to be able to figure out nationwide solutions for these really big crises. And the Supreme Court changed its mind and started upholding everything. And so now we switch from the Supreme Court saying no to everything under the Commerce Clause to saying yes to everything under the Commerce Clause, back to having this really big expansive view of the Commerce Clause. And what we have is from 1937 until 1995, the Supreme Court didn't knock down any laws saying that it violated the Commerce Clause, okay? So from 1937 until 1995, every single time a case came to the Supreme Court and said, we think this isn't really commerce, or we think Congress did too much, the Supreme Court said no. So for all those years, 1937 to 1995, the Supreme Court said, this is commerce, basically allowing Congress to do whatever they wanted, okay? By saying all of it was okay. And the, big famous case that we talked about was the Wickard case, Wickard. That's a farmer who's growing wheat on his own land for personal use, and he grew more than he was allowed to under congressional statute, and the court said this is okay, and this is commerce, even though he's not buying the seed or selling the wheat, he's just eating it himself with seeds he has, because in the aggregate, if you put all wheat together, then this would affect commerce. So this is a lot of deference to Congress, okay? Then the two other cases that we talked about are under the Civil Rights Act of 1964, Heart of Atlanta Motel and Katzenbach versus McClung. These are the ones that said that Congress was allowed to enact this legislation to help Black people in this country, to get rid of Jim Crow laws, to end segregation under the Commerce Clause, okay? And these are the types of arguments we already discussed about how Black people would travel more, there'd be more interstate commerce, Black people would go to restaurants more, so more things would be bought from interstate commerce by the restaurants, okay? So there were arguments about commerce, but it's still a really big, expansive view of commerce. So that's where we are up until 1995, and we're going to start a new video for that. Comment below if you have any questions about this really short recap of the Commerce Clause up until 1995.